All right, your panel on this matter is Justice Edgerton, Justice Adams, and myself. And you have requested 30 minutes for oral argument. Do you want to reserve some of that time for rebuttal?
5, please.
All right.
If I may please the court, my name is Crystal Morgan with Morgan Legal Services. I am co-counsel with Unite the People, Inc. and the Baez Law Firm for Mr. Daystar Peterson, who is the appellant and the defendant. We wish to begin by acknowledging the harm expressed in this case. For those that were affected, our arguments today are presented with the unwavering belief that our client, Mr. Peterson, is innocent, with the utmost respect. It's important as we would like to clarify that any display of empathy should not be considered an admission of guilt. That guilt is established in the bedrock of our criminal procedure that is from the prosecution. And in this case, that was riddled with numerous errors. That standard was not met. We believe the most compelling arguments are the testimony of Ms. Kelsey Harris when looking at the confrontation clause, prosecutorial comments in the opening and closing statements, and Brady violations that cumulatively occurred throughout the trial. To start with the confrontation clause, particularly with Ms. Harris, who was present in court and also present on the night in question with Mr. Peterson, Ms. Pete, and Mr. Smith on July 12th, 2020. Ms. Harris gave testimony on December 14th and 15th. These dates are important to note, but she only gave that testimony after asserting her Fifth Amendment rights. With the confrontation clause, what we must do is a very fact-specific analysis, and we must weigh Ms. Harris's right to not self-incriminate with Mr. Peterson's right under the Sixth Amendment to confront those witnesses. Because of this, we have to analyze this and take it step by step. So the first step is seeing if we have a testimonial statement. And this is according to Crawford v. Washington, 2004, 541 U.S. 36. These statements were further defined whether to be testimonial or non-testimonial by the High Court in Davis v. Indiana, which is found at 547 U.S. 813 in 2006. Statements are testimonial when the emergency no longer arises, when the statement is being given in response to a future prosecutorial event. So we know that Ms. Harris, when she gave her interview with the district attorney's office, was giving a testimonial statement. Therefore, the first prong is met. But the second prong is not so easy to establish. We need to determine if Ms. Harris was available or unavailable, which is a little tricky in this case, which is why we need to walk through each step. So Ms. Harris walked into court and said, "I exercise my Fifth Amendment right." That made her unavailable. But when they granted her use immunity, she was thereby available again. Yet she still got on the stand and testified in a manner that was not consistent. She said, "I don't remember." Or she said, "I was dishonest in my interview with the district attorney's office." Therefore, because of the way she was testifying, they decided at first to take this interview, which at the time we did not have a transcript for. And they were playing portions of the recorded statement to refresh her memory that the jury heard. So at first, that was going on in her direct. Then in her cross-examination, as she continued to testify in this varying manner that wasn't the way everyone expected her to testify, they entered the entire recording into evidence. But that recording was not entered into evidence while Ms. Harris was giving her testimony. It was entered into evidence on December 16th. And at that point, this is when the defense received that transcript, which we argue not receiving that transcript was a violation of Brady, and it also was a violation of Penal Code 1054.7, Your Honors. So we have this now statement in evidence, which is a transcript of a testimonial statement given to the prosecutors. In order to get this into evidence, they have first argued that they were going to use it to impeach Ms. Harris. This is because in their opening statements, the prosecutor said that Ms. Harris was going to testify that Mr. Peterson had violently pulled her by her hair from the car. This is a fact that was not proven at trial. Ms. Harris did not testify to this. Therefore, we feel that also is one of the inappropriate opening arguments. But additionally to that, we strongly objected to the late discovery of this transcript. And it wasn't just the late transcript. There were numerous other instances that the trial attorney did object to. But nonetheless, ultimately, the court did admit this statement under both Evidence Code 1235 and Substantive Evidence, Evidence Code 770. So now it's in, and we have a very unique situation here where we have a testimonial statement. We have a witness that doesn't want to give us answers and is saying I was mistruthful in my interview only in September of 2022, and this trial was in December of 2022. So it's clear that she did not want to cooperate. She said as much on the stand, I don't want to be here today. As a result, these matters, we feel that we need to look at the reliability and the prejudice to Mr. Peterson. And as Ms. Harris stated, I didn't tell the truth. So we can't rely on these statements from her own words. And this did greatly prejudice Mr. Peterson because in that interview, Ms. Harris said, my friend and I were attacked and it was this man's fault. And then at trial, she did not verify those statements, but the jury still heard those statements nonetheless. And we know that the jury relied on these statements because during deliberations, they did ask for a copy of that transcript to further analyze it. Therefore, we feel that the totality of this circumstance really does show that Mr. Peterson didn't have a chance to confront that witness in the Sixth Amendment context. Additional errors occurred throughout opening and closing statements. Start with the opening statements. We heard the prosecutor promise that he was going to put Mr. Justin Edison on the stand and that Mr. Edison would say that the following day when Mr. Peterson met with him to give Ms. Pete and Ms. Harris's belongings to him, that Mr. Peterson confessed that he did this crime. So the jury in opening statements at their first introduction to Mr. Peterson heard, he's guilty and he said so, and I'm going to put a witness on the stand to prove it. But Mr. Edison never testified in the trial. Mr. Edison was not being cooperative with the prosecutors. In fact, in November 28th, 2022, the court had to put a body attachment onto Mr. Edison. And on December 5th of 2022, Mr. Medesian, our trial attorney, actually filed a motion in limine specifically for this. And he stated that he was very concerned that Mr. Edison not coming to court would severely prejudice Mr. Peterson. And he urged the court to not allow such statements in opening. This motion was not granted. And so the court heard that Mr. Edison was going to testify. when Mr. Edison didn't show up due to media coverage and comments made in the trial, it was implied that Mr. Peterson was responsible for Mr. Edison not being in court with no proof of such contentions, which further prejudiced the jury. The body attachment continued at that point, and he still did not cooperate with the prosecution. We know in California, due to Hawk v. Superior Court, which is found at 42 Cal App 3D 108 in 1974, this is the controlling case that supports the contention that opening statements are confined to a reasonable good belief of what the prosecutor feels he will be able to show in the trial. Reasonable good faith, arguably, very respectfully, is not having a body attachment on a witness. The witness may or may not be trying to avoid the process. We don't know. He's just not there. And so that's all we can rely on. And ultimately, what happened is exactly what Mr. Medesian was afraid of in his motion in limine. And what Hawk warns about is that we must have this reasonable good belief in these opening statements to promise something, especially when it comes to a confession, because the jury is going to believe the prosecutor. They're going to rely on those words and have the prosecutor guide them and direct them to show why Mr. Peterson was guilty. So because of the great weight that the jury naturally gives the prosecution, we feel that these statements were inapposite to a good faith belief. Generally, a court would give a limiting instruction and attempt to cure such a situation. But in Mr. Peterson's court, no such instruction was given. There was no curative instruction for these opening arguments.
So let me ask a question here. So are you arguing that any time a witness is subject to a body attachment, that should be, that any reference to that witness should be off limits in opening statement?
I think that the prosecutor should be extra careful in such a situation because they're going into this knowing that that witness is not cooperative. So I think that if they say that they hope to produce such a witness, that perhaps would be enough. But here, there was just no hesitation. And I think it's especially true in the case of the evidence that we're dealing with Mr. Peterson, that it was a confession.
And so what was the evidence or indication that the people did not have a reasonable good faith belief that they would be able to produce Mr. Edison at trial?
We actually have no proof of the district attorneys ever speaking to Mr. Edison. The defense was never provided of a copy of any interview that they conducted on this witness. We have no physical evidence. All we have is an email from the district attorney in this case that said, I didn't disclose this and I meant to disclose it, but we are going to call this witness who will say that Mr. Peterson confessed to him. So I honestly, despite my best investigations, we cannot find where this statement came from. We cannot ascertain the veracity of these statements. That's why I think it's inappropriate. I don't think it's always inappropriate. But in this case, with these particular facts, I do feel that it's inappropriate. And there was also problems in closing arguments, which contained inaccuracies. And it presented the evidence in a way that misconstrued the actual results. Here, I'm specifically talking about the DNA evidence. So we heard the prosecutor close the case by telling the jury, don't be fooled when we hear that Mr. Peterson is excluded. But that's not exactly what the evidence said, which they had in their possession. I feel that statement really misled the jury. It may have confused them. It played on their emotions. And we know that that's not appropriate in closing statements. And in order to really understand the weight of that statement in closing, we need to understand what the evidence was that the district attorney had available to them. So as shown in our brief, in our reply brief, as for the magazine, there were 4 DNA profiles discovered on the magazine, none of which that were Mr. Peterson. Therefore, he was excluded from the magazine. As far as the firearm goes, they also found 4 different samples, one of which was a 90% male contributor. But Mr. Peterson was excluded from being that 90% contributor. Therefore, telling the jury, don't be fooled when you hear he's excluded, is just not quite as the evidence showed. And to illustrate this, I want to clarify some key terms in science. So inconclusive, we heard in trial testimony, means it's not positive, it's not negative, it's just a neutral result. But it's not quite as simple as that. Actually, according to the scale of a likelihood ratio, which was in the discovery and presented at trial, likelihood ratios are the percentages. And we did not hear any percentages in Mr. Peterson's case, even though this evidence was available to the prosecution. This evidence was only given to defense upon our expert witness's request. So we did receive this evidence late. So this evidence was not presented in trial. It was presented in the motion for a new trial. But what we can see is that likelihood ratios that are 0, 0.01 and below are considered to be excluded. Likelihood ratios from 10,000 to 999,099 are very strong, very strong support to the prosecution that this person did leave DNA on this item. And then above 1 million is very strong. We found in the DNA evidence that they labeled Mr. Peterson's LR to be inconclusive and uninformative. And uninformative, according to this scale, is this an LR of 1. Therefore, Mr. Peterson had an LR of 1 in a million that his DNA was on this firearm. And with that fact, it is actually marginally more likely that another member of the African-American population touched this gun over Mr. Peterson, which the jury did not hear. The jury heard the district attorney say, don't be fooled. But there's also no proof that Mr. Peterson did anything to fool anyone about this evidence. He presented his defense. It was their testing. We went off of what their testing said. So I just think that that is a very strong contention. People v. Berryman in 1999, 21 Cal 4th to 50 is a significant California Supreme case that addresses the standard for overturning a conviction due to prosecutorial misconduct. It's a principle. Basically, the key outcome of that case was that we must show that this misconduct materially affected the outcome of the trial. And it did, because if our jury had heard that Mr. Peterson, maybe 1 in a million, touched the gun, I believe that would have been enough to tip that scale and show reasonable doubt for them to find him not guilty. The jury just didn't hear that. They heard that Mr. Peterson hoped that they would be hoodwinked in the alleged closing arguments. So due to these statements and the misconstruing of the evidence, we feel that that was a very significant issue in the case. And finally, we feel that the Instagram post, as we discussed in our opening brief, this was a Brady violation. This post was given not only late, but it also was not redacted. It was riddled with hearsay. This post is significant as it also implies a confession, because what we have is actually various people posting, and this was in September of 2020, and they were posting that people were saying that, oh, well, if Mr. Peterson didn't do it, then Ms. Harris must have done it. And Mr. Peterson's social media manager commented on this post, no, they're not. And so that was used as an admission. But many celebrities don't run their own social media accounts. This is significant because, number one, had that discovery been given timely, we could have provided the statement that was provided in the motion for a new trial by Mr. Farias, stating that he is the one who runs Mr. Peterson's social media account. He made that post, and he didn't ask Mr. Peterson before he made that post. So that right there, we could have, if it was not late, presented a defense. But because we didn't have that, we were caught off guard. We were always in a position of reactive instead of actually being able to produce a good defense on this case. The Brady rule provides...
Let me just ask one question at one thing you said.
Yes.
Were there requests for redaction of that exhibit or of the post?
I believe there were, yes. Mr. Medesian did do a very good job objecting throughout the trial. We also must remember that Mr. Medesian only took over this case 2 weeks to a month prior the start of the trial, because the first trial attorney did withdraw and was permitted by court. Yet, I understand the court allowed that, but as an attorney, that's a very big feat to step in the shoes of another attorney so close to the trial. So I feel that all of these arguments we're discussing today, we do need to take that into consideration overall with them and think, in the alternative, this could be an effective assistance of counsel. But the Brady rule provides that this exculpatory evidence must be provided to defense whether or not a request was made. The suppression of this evidence, it doesn't matter if it's willful or accidental, so long as it was suppressed, then that is the problem right there. And I do have a 3-part test, which is found in the United States Supreme Court in Strickler v. Green, which is 527 U.S. 263 in 1999. They reiterated the 3 components of a Brady violation. The evidence must be favorable to the defendant. Here, yes, the evidence was favorable. Had we gotten that Instagram post earlier, we could have brought that declaration in trial saying Mr. Peterson doesn't run his own social media accounts. Had we gotten the DNA evidence and not had to request that from the prosecution, we could have prepared for a better DNA argument, having the full picture. Had we had the testimony, the transcripts from Ms. Harris's interview, we could have countered that. We could have questioned her on cross about her interview. We also likely did not get fingerprint evidence on time. We did not get, and the fingerprint evidence actually showed that Mr. Peterson's fingerprints, were not found on that weapon. Currently, we are attempting at the Superior Court to have them run the serial number to identify the owner of the weapon, which was not done. And we are also attempting to retrieve either a recording or a transcript of one of the key witnesses' testimony. One of the key witnesses in the case, Mr. Sean Hawley, who gave testimony. We're attempting to get a copy of his 911 call.
Wait, you said Sean Hawley?
Sean Kelly.
Oh, okay, I'm sorry.
Yes.
I thought you were referring to
Very,
counsel who's female. Okay.
yeah, no, very close. Yes, Sean Hawley was the attorney. Sean Kelly was the witness.
Okay, got it.
Different spellings also. So obviously we can see that this is favorable. The second question under that three-part analysis with Strickler was it suppressed willfully or accidentally? Yes, this evidence was suppressed. All of these different pieces to where Mr. Medesian said, I feel like every day I wake up and I have an email from either the night before or the morning of saying, oh, we missed giving you this. And very respectfully, I say that. And the final component of this three-prong test is, would it have changed the outcome of the trial? Yes, absolutely. If our jury could have heard the full picture, the full accurate picture of just the evidence being laid out as it was, without these don't be fooled and, late discovery, I feel that it would have really tipped those scales to reasonable doubt to find that Mr. Peterson was innocent. And that's why today we humbly pray for exoneration of Mr. Daystar Peterson.
Thank you very much.
Thank you.
Morning, Your Honors. May it please the Court, Deputy Attorney General Michael Keller for the respondent. I want to begin by discussing the compelling nature of the evidence in this case. Within minutes of the shooting, the police found the gun that was used under appellant's seat. There were only 4 people in the car. Pete and Harris both identified appellant as a shooter. That first ID occurred within minutes of the shooting when Harris sent a text to a member of Pete's security team saying, help, Tory shot Meg, 911. Harris again ID'd appellant as a shooter in the recorded statement, and we can get to that in a moment. And Pete identified appellant as a shooter both before trial and at trial. Neither of them ever suggested that anyone other than appellant fired the shots. Now, there's 3 times in which appellant tacitly admitted being the shooter. The first is hours after the shooting, appellant made a recorded call to Harris stating that he didn't even remember what they were arguing about, and he wanted to know the hospital where Pete was being treated. He blamed alcohol for the quote unquote shit that he did. Now, the second one was later that day, appellant sent a text to Pete, to the victim, and that text was preserved. In it, appellant said Pete would probably never talk to him again, that he was sorry, and he blamed again the alcohol for the quote unquote shit that never should have happened. And then the third and final is the verified Instagram post that I'll also get to. Now, appellant's assertion is that he really wasn't accepting blame for having shot Pete, but for causing a rift in the relationship between Pete and Harris. And that's just nonsensical. First of all, Harris told the appellant she was at the hospital waiting for Pete. So if there had been a momentary rift that night, it was over because she's now at the hospital waiting for her friend that she's known for 7 years to be released and checking on her. Second, appellant didn't apologize to Harris, but yet he anticipated that Pete would never talk to him again. He was clearly accepting responsibility for something very big, something that applied to Pete, but not to Harris. And as appellant said he couldn't remember what they'd argued about, he wasn't accepting blame for anything he said. Finally, appellant said that he expected to receive backlash once word got out. Now, backlash for causing a rift makes no sense, but backlash for shooting someone does. The evidence in this case was compelling. Turning to a few of the issues that have been highlighted here today, I'll start first with the Instagram post. This was appellant's verified account. And a few times today I heard opposing counsel mention Brady, but Brady was never mentioned in appellant's opening brief or the reply brief. It can't be raised for the first time at oral argument. And frankly, it has no application here. because the things that were turned over were inculpatory, not exculpatory. So when it comes to the Instagram posts, they were turned over upon realizing them, and there was no, many of the case, as you'll see in the respondent's brief, many of the claims that appellant raises are forfeited by a lack of objection at trial. And one of the things Your Honor asked is, did counsel ever ask for redaction? I don't see that anywhere in the record when it came to the Instagram posts. In fact, counsel didn't even object on the discovery basis. The objection was solely based on foundation. So discovery doesn't work for appellant on appeal. And as to foundation, the question really is whether or not there is an inference that can be drawn that a statement was made by a party. If so, it falls under the party opponent exception to the hearsay rule. And in this case, it's a verified account. And the fact that there may have been somebody else who had access to it to respond and may or may not have had permission, that would all go to weight, not to admissibility. Turning to the issue raised about the Harris recording.
Let me ask a question about the Instagram post before you move away from that. And I guess the question is, if there were some sort of error in admitting that post, what would your argument be about as to whether that was prejudicial or not?
Yeah, it certainly wouldn't be prejudicial, Your Honor, because first of all, at trial, it came out about these other aspects. In other words, do we know for sure whether or not this was appellant personally authored or approved of it? There's some question about it. But what we do know is he did send the text. What we do know is he did make the recorded phone call. Like, that's his voice. So, and by the way, I would say that on the Instagram post, the post, all it said was Harris didn't do the shooting. He didn't say, I did the shooting in that. So it's no more incriminating than the other admissions that came from his phone in a text or in person in a voice recorded call. So turning to the tape recorded statements that were made by Harris to impeach her as prior inconsistent statements. When she was on the witness stand and made a number of inconsistent statements, the prosecution impeached her with those prior statements. Much of the recording, pieces of the recording came out during that period of time. While she was still on direct exam, the prosecutor announced a desire to play the entire recording at a subsequent time. And that was that's 5RT 3664 through 3665. Now, this puts the defense on notice that the entire recording is going to be played. The defense has an opportunity to object to it, to portions of it, and counsel doesn't do so. Counsel instead has an opportunity then to cross-examine on anything and everything that's in the recording because counsel knows that the entire recording is going to come in. So a confrontation clause claim just doesn't lie. And then I would add that on top of it, Harris wasn't excused as a witness. At the end of Harris's testimony, I see nothing that would preclude Harris from recall. So a confrontation clause is for when the defense doesn't have an opportunity to cross-examine a person on it. Harris testified, although Harris initially took the fifth, Harris was given immunity, subsequently testified. So the confrontation clause just does not work on appeal. And lastly, I'll turn to the allegations of prosecutorial misconduct. On that, again, these are forfeited claims. Objections weren't raised. Your Honor asked a question about how do we know on good faith, bad faith versus, there was a body attachment. You have a prosecutor that is because the trial court did inquire into it, and the prosecutor said that the witness was under subpoena, and the prosecutor said they had a good faith. That's a judgment for the trial court. Now, I would note that if the defense counsel wanted more information about it, that was the time to raise it and to try to develop more details right then and there before the ruling as to whether or not this witness was going to be available and whether the prosecutor actually had a good faith. And the defense's failure to do so precludes the claim from being raised on appeal. And one of the things I'll note that is in the reply brief as to these allegations of misconduct that weren't raised below, the reply says, well, an objection would have been futile because it would have run the risk of highlighting the issue for the jury. That's not what decisions involving futility involve. The futility exception applies only if the record shows that the objection would have been overruled or that nothing could have been done in a curative fashion, not just that it might highlight an issue for the jury and the attorney had a tactical reason for not doing so. Unless the court has any questions, I'm prepared to submit on the brief and ask this court to affirm the judgment.
We have none. Thank you very much.
Thank you.
Any rebuttal?
Yes, briefly. Regarding the text to Mr. Edison, there was actually a motion in limine filed regarding that text. It was filed on December 12th, 2022 by Mr. Medesian. He stated that without Mr. Edison present in trial and without the foundation laid, that this text message shouldn't be admitted. That objection also was not granted by the court, but was on the record nonetheless. I've heard the people say that there was not compelling evidence, or there was compelling evidence, excuse me, to find Mr. Peterson guilty, but I argue that there was not enough evidence because we talked about the physical evidence in this case and the lack of physical evidence in this case. We discussed the variance in testimony where even today, it's still not quite clear what happened on that night. And I also want to talk about the Instagram post. The fact that Mr. Peterson didn't say, well, you know, it wasn't Miss Harris and it was me, that really doesn't matter. There were only 4 people present the night in question. One was Mrs. Pete, one was Mr. Smith, who was the driver, leaving only Mr. Peterson or Miss Harris in possession of that weapon doing the acts that we're here for today. Therefore, it doesn't matter if he didn't confess. It was an implied confession because there was no question as to whether Mr. Smith or Miss Pete ever did these actions. I would like to remind everyone that Brady is willful or accidental. Brady says that regardless, the defense has a right to the evidence that's being produced against them in court. The incidents were very significant. The pieces that we were not given would have changed the outcome in this trial. For example, with the Harris recording, there also was an objection there for the Harris recording. That goes back to our motion in limine on December 5th. And in that, when there also was a sidebar as this was going on and these statements were being played to first refresh Ms. Harris's memory, you know, Mr. Medesian did object and there was a sidebar and the judge actually commented that it's just easier this way. And Mr. Medesian said, but procedure, and the judge said, no, it's fine. We're going to do it this way today. So those objections were raised in the courts. Those weren't waived. And honestly, as far as recalling Ms. Harris, there was no body attachment. She stated, I don't want to be here. I don't want to do this. She stated, I have not been truthful. And I can't speak for Mr. Medesian. So there is no record of why or why not she was not recalled. But I feel that the people did just make a good point that it was futile. I feel that at this point, Mr. Medesian very respectfully did feel defeated. He did feel overwhelmed. He stated in his objection, I wake up every day and have an email from late last night or this morning with another piece of evidence that the people forgot to give us. And I do feel that he lost some of his steam there, so to speak. And because of that, that's why I reminded the court that he had that very short time to prepare, and any objections that were missed should be construed as ineffective assistance of counsel. And in that, I submit.
All right. Thank you both very much. The matter stands submitted.
Okay, the matter stands submitted. I'm interested to know what you guys think.
Yes, we're in recess until 1 p.m. Thank you.
Thank you. So what I'm hearing is from the defense, they did make some good points. She basically saying the previous lawyer, he felt defeated. And so, and I guess the prosecution is saying, hey, it was insufficient. They weren't good lawyers, insufficient of counsel. They were trash. They didn't do their jobs. But what she was saying, well, he felt that way because, first of all, we never had the transcripts from Kelsey's meeting in 2020 with the police. Okay. It wasn't until Kelsey got into court and started lying and saying she didn't remember what happened. Remember, when Kelsey got to court, she had forgot everything. But you also got to remember, her and Megan Thee Stallion had fell out. So she had stopped talking to Megan Thee Stallion by the time she had came into court. When the shooting first happened, her and Meg were cool. Kelsey went and did this report with the sheriff's office and said that Tory shot Meg. It was this, that, and the third. All this happened. Once the trial happened, Meg had cut Kelsey off. She had got signed to Rock Nation. She had moved away. She had stopped talking to Kelsey. Kelsey felt slighted, came into court, and did not want to testify on the behalf of Megan Thee Stallion. So she played like she didn't remember. She didn't know what happened. So she became a volatile witness. So then what they ended up doing is they brought the recording into the trial. However, the defense is saying, well, we didn't have any transcript of that until later. We didn't even know that was going to happen. But the prosecution is now saying, well, you guys could have objected to that. You could have objected or to certain parts of that not getting played, but you guys didn't do so. The defense is also saying, well, hey, how are we going to say that Tory Lanez did this when there was a 1 in a million chance that it was him because his DNA was not on the gun? It was a black person, but it wasn't him. And then his fingerprints were inconclusive. The fingerprints on the gun were inconclusive. And this test was not ran by the defense. This was ran by the prosecution. But instead of having, in a nutshell, what the defense is saying right now, instead of having hard, concrete evidence that Tory Lanez shot Megan Thee Stallion, they use buzzwords like "don't be fooled." They use things like Instagram posts, but when celebrities have Instagrams, the manager could have made the post. And because he said Kelsey didn't shoot her, doesn't mean that he implied that he shot her. So there is no smoking gun here proving that Tory Lanez shot Megan Thee Stallion. So for that, they're asking that he be set free because it was an insufficient amount of evidence directly proving that Tory Lanez shot Megan Thee Stallion. So there was reasonable doubt, is what she's saying. And so after listening to this and being there, I'm like, well, there was, I mean, there wasn't a smoking gun. His hand wasn't on the DNA. But at the same time, the prosecution is saying, well, what was he apologizing for? Why is he saying that man would never talk to him again? Why was he saying that she didn't deserve this? He was drunk that night. He's going to get backlash. What was the text message from Kelsey immediately that night saying, quick, Tory shot Meg? Why was Meg and Kelsey in the back seat sitting together while Megan was shot? If I shot her, if Kelsey shot her, why would Kelsey be in the back with Megan's leg on her? Also, if Megan was just so shot, why would she get in the car? If the nigga just tried to shoot, it's just so confusing. Why would you get in the car with someone that tried to blow your feet off or tried to shoot you? I'm not getting in the car with a nigga that just shot me deliberately. I don't know. I feel like he did shoot her because I feel like Tory Lanez has a history of just being violent and being crazy. But at the same time, did they really prove that he shot her? No. And then the fact that she got in the car, I'm not getting in no car with somebody that tried to kill me. Ciao. So we're going to take a couple people on here. What do y'all think after hearing that? Did Tory Lanez shoot Megan Thee Stallion? Let's see. I dropped the link. So how do you guys think this appeal is going to go? Do you think that they raised a good argument? Do you think Megan Thee Stallion lied? Do you think Tory Lanez just didn't have great counsel? And remember, Kelsey admitted that she lied. Meg lied at first and said that she stepped on glass. Why would she do that? But Tory didn't get on the stand. And I just don't understand that. If you didn't do it, why would you not get on the stand? Hey, what do you think after all this mess? It's still not clear.
It's still muddled. It's still not clear. I will say though, oh, can you hear me?
Yep.
Oh, okay. Sorry, I got thrown off because I also have it on my TV. Sorry. I'll say that I was a little thrown off because I didn't love Tori's lawyer at this oral argument. She seemed a little shaky. I didn't really love her.
Mhm.
However, I did follow her argument, and I like that she kind of slid in ineffective counsel in there because what I felt interesting is that when the DA came to do the rebuttal, he basically talked about how crappy the attorneys were. And I
Right.
was like, okay, are you helping? Thanks, but should you be doing that? So I think if the appellate court accepts this, it's going to be because the DA handed it to him.
Mm. That's a good observation.
Like argument after argument was the lawyers didn't do this, the lawyers didn't do that, they didn't do this, they didn't do that,
That
and I'm
was
like,
true.
you know what I'm saying?
So it's kind of like he just didn't have a great counsel. So, and if they would have, this would have been a different outcome. And essentially, that's what Tory's lawyers are saying right now, the new one.
And that's the basis for appeal. So I was like, I don't know if he meant to do that.
Mm.
And then I know you got somebody else. I'll be real quick. Another thing I noticed is that when he first came on, he was making arguments that I think didn't hold water. Like, what do you mean that um, causing a rift between two girls is not going to have backlash?
Are
It
you
will
crazy? That
absolutely
would have
have
been all
backlash.
over the internet.
Exactly. So I was like, oh, this guy, I don't know where they got him from, but I'm a little concerned.
All
Thank
right,
you.
thanks, Boo. Princess, go ahead, talk to me.
Yeah, I would say the reason why I really don't feel that Tory would do something like that, because the intent, like, what would be a reason why he would be angry? You know, as far as like to want to shoot somebody in the foot. Like, I think it was Kelsey and Megan like fought and stuff, and they
Mm.
were the ones that had more anger intent towards each other. Because what would Tory be angry about?
Well, apparently Megan Thee Stallion was yelling a flagrant of obscenities to him and saying that he wasn't shit and then he was trash and he and mind you, Tory exposed that Meg was sleeping with him while he was dating Kelsey.
Hmm. Yeah, because I understand that too, but it's like it would be no real reason for him to do that, because you know, like how arguments be with, you know, a baby daddy or a baby mom, and they get in an argument. It's no real reason for him to like even want to put as far as like shooting her. Maybe I'll
Mhm.
say like a fist be thrown before, you know, a shoot, like actual gun
Yes.
being involved.
So my other thing is somebody made a good point. Why would Kelsey need immunity?
Right.
If she was just
That
getting beat up and she was just a victim, what would she need immunity from?
Yeah, I would say that the real reason why Kelsey might use the immunity, because she might have seen that behind the scenes that maybe Megan end up switching up on her, and you know, as far as like not wanting to be around her anymore. So maybe she said, well, I'm not gonna have your back since you're doing this, you know?
Yes, thanks, Princess. Thanks, Boo.
You're
I gotta take
welcome.
another caller. All right, Ben, talk to me.
You can hear me, Armand?
Yes, what you thinking? 1098. Thank you, Ben. All right. Paula.
Hey, Armand.
Hey, what's going on?
I'm good. I just wanted to say, to answer your question about immunity, um, I'm just thinking of it as myself, like
Okay.
in this particular thing, as far as the shooting. Just as the people are saying that Tory is innocent, I would do immunity too, because what if somebody falsely accused me? So I don't even want that to be
You
a
don't even want to have to fight
concern.
that. You don't even want to
Right.
have to
I
fight
don't
that.
even want that to be a concern. So I don't think people are really thinking logically, on that. You understand what I'm saying? Like putting
Yes.
yourself in that.
I don't even want to be too deeply mixed up where then I could be charged for something and I'm fighting and I didn't do it.
Right. So it doesn't necessarily mean that she's trying to protect herself because she did it. It could be
Mhm.
that she doesn't want any talks of it to even come, her way. And then another thing, as far as you said, well, why
Hold
did
on. Let's
Megan?
land on this point real quick
Okay.
because talks of it is happening. So I guess what you're saying is even if now, because everybody is saying Kelsey's the shooter, but with the immunity, that might protect her from even being charged.
Right.
So
Right.
I get it.
And then regarding you stating, as far as why did Megan get back in the car? Well, from based off of the information on what was told, because I've listened to it and gone through this trial, looked at the exhibits and everything. So what I think is they hadn't planned on telling anything, talking about
Mhm.
who said what. That was the whole reason why Megan stated she stepped on glass. That was the original reason why she said that, was because nobody planned on coming forward with saying that she was shot. I mean, even when Tory called on the jail phone call, um, uh, Kelsey stated, "Well, Megan's team is handling it." On the jail phone call. So I don't even think that they had planned on saying anything. Now I don't remember
But hold on
Tory's.
though, because I feel
Okay.
like that's what maybe you're right. But I feel like Rock Nation and Desiree Perez had a different plan because even at that, Kelsey did not know that she was slowly being removed due to Megan's team. So Rock Nation had already decided, yeah, maybe we're going to tell the 3 or the 4 of you guys, we're going to have you thinking that this won't get out, but whatever has happened, we're going to make sure that we protect our asset, Megan Thee Stallion. But everything that was in that car, including Kelsey, the driver, Tory, you guys are fair game, and it's you versus her now. And all y'all got to go, because look at it. She's with them now, and none of them are close anymore. Kelsey and Meg are not cool. Tory's locked up. So Desiree Perez had a plan. She was the intern between Megan and everyone else. So she was facilitating protection for Megan Thee Stallion. And she was at the court every day. So they had a different plan there.
But that's on a business aspect. Megan is their artist.
Well, is this not business? Was this whole thing not a business move?
Well, no, that's
whether
not
they
what,
saying something or not.
That's not what I'm saying. What I'm saying is that you're protecting, like you said, you're protecting your asset. So what I'm saying is, matters of how everything is going to be construed in the media, you still don't want that person associated with the different people who have things going on. Okay, so that's kind of how I'm looking at it. Okay, but like I said, I don't remember the post or when Tory came forward, because I heard some things allegedly that that he had said something that was the whole reason why Megan came forward and said that he shot her. I didn't see it, online, what he said or he did, but as far as that is the reason why she came forward. She was going to continue with the lie as far as, she stepped on glass. And then another thing, them saying she stepped on glass when she stepped out of the truck. There was blood already in the truck. There was a towel with blood already on it inside the truck. So, that to me didn't even, that wasn't even correct. Because I've seen different videos come out, with the glass. It seemed like somebody put glass to make it sound and seem like that's what it was. It's just been funny. It's just been crazy, and people just believe, anything that's on the internet instead of researching it. I mean, when somebody says something, I'm going straight to the exhibits trying to look. I even pulled up the x-rays trying to see if the place where the bullets fragments.
But then my thing is, the bullet fragments disappeared. And let's speak to the DNA. There was no DNA pointing to Tory. None. I'm not saying he didn't do it, but I'm just saying, like, if we're just saying from a legal standpoint and you have to prove it, did they really prove that he shot her? And now I'm thinking, like, I feel like what you know, like you feel like, okay, he did it, but I don't know if they proved it.
Well, it seems like they had other things that didn't make, that they brought to the table. Not so much as that, because it was like 90% male. So that means that that's not Kelsey. I mean, they brought other things to it. And then this is what I'm saying. Kelsey doesn't seem to me someone who just shoots someone.
Yeah.
So what I'm saying. So I'm just saying, for her to be how she was calm. If I was to shoot somebody, I'd be all over the place. You understand what I'm saying?
Me too.
Yeah. So when she was speaking to Tory on the jail phone call, she was so calm, collected. She wasn't even scared or anything. And even when she texted 911, Tory shot Meg.
Yeah.
Who thinks of something like that within a couple of minutes? You understand what I'm saying? If it's a lie.
And let me ask you this, because I'm just like, it's like one of those things, like, I just feel like, even though there was no smoking gun, just the way he was talking just gave off you were the shooter. But here's the thing. I do believe if there was a shot, but I don't know if I believe that he deliberately pointed and shot her in the foot. I don't know if he was just shooting, or if there was shooting, if there was a rustling or tussling over a gun and a shot went off and it ricocheted and grazed her. But I don't think that he shot her in the foot. Does that make sense?
I believe that too. I don't think it was done intentionally. Okay.
No.
I think that, I'm not saying that he didn't do it, because I believe that he did. But I'm just stating that I believe that he may have shot in the air, because when Sean Kelly stated, he said that he had his hand, it was moving around in the air. So
But
you
he
go
also
look.
said it was Kelsey and Tory.
Right. But think about it. That's why I say people don't think. When you're traumatized or something, seeing something like this, sometimes you're not thinking straight. You don't know, the things don't come to mind right then. People are just thinking that that even with a victim statement or anything like that, they think that they just going to tell the truth, tell the things that happen right then. So what I'm saying is the point is that he did say that, but then he went back and said that the little guy
Yes.
had the gun.
Yes, he did.
So he didn't wait until he got to court and change his story. He
But
said
he
it.
also said, but see, okay, but Sean Kelly also was saying it looked like that Kelsey and Tory and the security guard were all beating and jumping Megan and picked her up and looked like they were going to throw her in a ditch.
Now I never understood that. And
Yeah, you know what I'm saying?
yeah, but he's the you know he's the that's what he's just saying what he saw. I
So
mean, he
yeah, so
said
we
what he
got to
saw.
get into it. They're trying to get that 911 call, so that'll be interesting. Thank you, Paula.
You're welcome.
Okay, Big B, what's going on?
What's going on, Mom?
What you? Oh,
Thing
your
is,
service? Go ahead, talk to me.
you hear me?
Yes.
My thing is, facts are facts. When cases like
And
this
what
are
are
so,
the facts?
was
Oh,
100% on it. They said a male. How many people were in the vehicle at the time? 4, correct?
yes.
How many males were in the vehicle at the time? 2, correct?
2.
If it wasn't Armand's fingerprints, did they test the other fingerprints?
No.
Hmm. Shots fired. Next thing. My thing is, these cases are not solved off of accusations. They're not solved off of who do you shot them. It's solved on fingerprints. His fingerprints were not on there. So how did they come to the resolution that it was him?
They got it through text messages, testimony, Instagram posts, and assumptions.
Social media and assumptions, not facts. The glass fragment thing, just like you said, what happened to the bullet fragments? What happened to it?
We don't know.
Here, don't know. Security guard who actually fingerprints probably are. So
Okay, your sound is tearing me up, boo. Come back later. Because he ain't got no reception where he at. We'll take a couple more and it will be dropped out because that reception was tearing me up. You got to get some better reception. So let's take a couple more and then we're gonna head on out of here. Kelsey, Kill with Kindness says Kelsey and Megan was all over the place. It's in the transcripts. They both committed perjury. Okay. I don't know how this will end. Megan Thee Stallion seems to be still living her best life. Tory Lanez is fighting for his life still. So, child, I don't even know what I believe. I feel like I don't know. Let's get Jaleesa in here. What's going on?
Hi, can you hear me?
Yes. So what do you
Okay,
make of
perfect.
this?
Okay, I've been torn from the start of this, but I really wanted to say this. Do you remember when everybody was deliberating in the courtroom, the jurors? And what happened was there was one of them that sent out a note, and the note was, how do you say like a legal term for like on accident or on purpose or something like that?
Mm-hmm.
And they brought back the note and they said there's no terminology for that. Now that told me two things. It told me that they were questioning intent,
Yes.
and they were obviously not going to give them wordings because that's just not what the courts does, because they don't want to feel like they're leading them to make a decision or come up with anything. They want them to come up with it on their own. So when they started to question intent, that's what makes me think that it wasn't on purpose. And I do believe that they were fighting. And because she had hot gravel in her foot, I was thinking maybe he shot at the ground to get them to stop and it grazed her, or like the hot gravel is what, because her foot doesn't look like, it didn't look like gunshots. It almost looked like it was glass because there was all these little like nicks and cuts, and it was very weird. It wasn't something consistent with a bullet wound. So
Right. It did not look like a bullet wound. It looked like a deep cut.
yeah. So that's why I was thinking maybe
And so you're right, because now what we do know is, and neither Kelsey or Meg wanted to tell, that they got out and started scrapping.
yeah, and yeah, they
And
she
Tory
was
was
not
trying to
on that.
break it up at a point too. So I don't know if
I
that was what was the gun, but then remember Meg said that he told her, dance be dance when she walked away. So it's just like, it's so many different stories, but
well,
it's not making sense.
I will say that what made me kind of torn between what Megan was saying and what everybody else was saying is because I initially was on Megan's side. But when, the dance bee thing, according to how the person saw it when he was looking out the window, that doesn't really add up. And then the positioning of when she said how she got back into the car and where she was sitting, a lot of those things that she had said no longer made any sense. I do feel like she was coached to kind of make it. I think
She was
somebody
coached to
somebody
get
asked
the
about
job done. So that's when
somebody
we start
said how
talking
was it
about the
hot?
team. We get
Yes.
into Rock Nation and we say, well, this is what happened.
Somebody just said the hot gravel, they weren't sure about that. But no, what I'm saying is that because the bullet is so hot and the shrapnel and the gravel itself would have been hot from the projection of the gun. That is why it looks like she has so many cuts and scrapes on her foot. That's what I was explaining. But I don't want to take too much of your time, but a lot of the stories and
So
inconsistencies
what do
don't
we
add up.
think now?
I do think that it was something that was an accident, and I think that they knew that. That's why they were questioning intent.
And so are you saying, what I'm hearing you saying, I don't want to put words in your mouth, but
Mhm.
you saying that Rock Nation and Desiree Perez went ahead, and because it was so gray and whatever dealings they had, because Megan was their asset, Tory
Yeah,
Lanez obviously was becoming a problem. And so they just needed to wrap this up in a bow and get him gone and get this and protect Megan Thee Stallion. So they went ahead and tied the story into her favor in a way. All right. It's too many gray areas. This is going to get out because there's too many high profile people involved.
yeah.
So what we're going to do now, this is the story. We're just going to go ahead and round it off and narrow it down. This is the story. And Megan, Kelsey has to go. Tory has to go. If you want this to go to the next level, this is what we have to do.
I think that is
And you sign
definitely
in
what
blood.
I'm believing that now. Only because it is very interesting that, and I want people to understand that it's the people, what was it? Is it the state of California versus Daystar Peterson? So it's not
Yeah.
so much about like Megan's this bad person. I just think that she was coached poorly. And I think that it has done a lot for her that she went in this direction. And I think it wasn't the best. She couldn't keep up with a lot of the things that she was saying. None of it was consistent. I'm sorry, it doesn't sound right. It sounds weird.
Because it's still not clear.
No,
And
no.
I just feel like the other part is like everybody was like, we know what a gunshot looks like. And we just feel like
Mhm.
that didn't look like a gunshot wound. And then
And you
remember, it
think
was
about
supposed to
in the
be in
club,
both feet.
yes. And then when she went to the club, she was fine. But then when somebody said something about it, the next time she went to the club, she had a bandage on one of her feet. So
Yeah.
yeah, I'm
It's
sorry.
not all the, to me, I'm still, maybe a gun was fired,
Yeah,
but it wasn't like a shot directly in the foot. But the thing is, if you shoot at me and it ricochets you
yeah,
shot
yeah.
me.
I was gonna say that as well. Like, I kind of came to the conclusion that at the end of the day, they probably feel like, well, okay, who cares if it were an accident? Somebody could have been killed, right?
Right.
And I think that they're all trying to avoid, the fact that they were all drunk and stuff like that. And I just think that the other reason why they didn't want to question intent or whatever or go another route is because they're trying to prove the state of California just wants to have a gun in his hand because then that ruins wasn't he on like probation or something like that?
Yes, yes.
I think they just wanted to prove that there was a gun around him or in his presence, and I think that was the easiest way to get him to say that he was not
And
he
on
wasn't
top of
doing
the
what he's supposed
fact,
to.
and on top of the fact that if we uncover too much from the state side, we didn't have to reveal too much about Megan Thee Stallion, like you said, and like it gets too muddy because it's like, well, how drunk were you? Were there drugs? Like what, like everybody's skeletons gets put out to a certain degree. And I think that they were trying to protect her in a way too. Like we don't want to open up too much on her, but so we got it. Like, that's why I feel like it's not clear, because I don't even feel like all the story is being told
No,
on both sides.
no, I don't. I feel like everybody's trying to protect themselves and their image. And we can say that some people may want that a little more than others, but they're trying to protect their image. And I think people saying, people are coming at Kelsey and saying she's not a girl's girl, but neither is Megan. This started all types of wars, women against women, black people against black people, black men versus black women. Like the media ate off of this a lot. And I think that everybody's just trying to protect themselves.
Okay, Tiffany, thank you. Thank you, Nicole. Jaleesa, go ahead, Tiffany.
Okay, I did want to speak. First of all, thank you, Armand, for covering the case and everything. Even previously, when you covered it originally, I first started following you because of your coverage. You was like one of the very few, I think it was only like about two on YouTube who was like unbiased and told the truth. So thank you for that. Okay, but I want to say, I feel like there is a smoking gun that a lot of people, it just seems like a lot of people are dismissing and not really considering the fact that
Okay.
the victim is still alive. Most people, when they do this kind of a crime like murder or K-wording or doing the pew pew to anybody, like that's like the number one rule is to make sure that they're actually gone, that they're actually unalive and get rid of witnesses and everything. But that didn't happen in this case. The victim is alive and the victim ID'd who the Uter was. And I'm trying to like just
I got
say
it.
the words. I hope you understand what I'm saying. Okay. So the victim did identify who the Uter is. And I don't understand why everybody is dismissing that. Like it's people who have been like really, really gravely attacked, like burn victims or something like that from domestic violence. That's the first thing police are trying to do before this person passed away is come up in there and get them to get it on record and record who did this to you, who did this. That's the smoking gun. That's the number one thing that a lot of people are looking for. Besides now people are looking for video. Nothing can actually beat a video. But before we really had a lot of video, the number one thing was the victim, the eyewitness.
But I think, and I'm with you, but I think the problem here is the victim is alive, but this wasn't her, number one, this wasn't her case. This was the state picked this case up, right? I'm just playing devil's advocate. Then two, once we get into it, the victim has lied multiple times on television and interviews to the police, right? And then there was a lack of evidence when we say bullet fragments were, disappearing. DNA, his DNA was not found. But Kelsey was not tested. Okay. His DNA also, the DNA also was found, what was it? Inconclusive. So it leaves gray. I get what you're saying, but it leaves gray area for people to say, well, what the hell?
Well, I would say to that, Armand, I would say that totally makes sense that his fingerprints wouldn't be found on the GUN. I don't know if we can say that, or the gun. Like that's what people do when they commit a crime. They wipe down the gun. Like, so I'm pretty sure that's exactly what he did. So that made sense. As far as her lying, the only thing she lied about that actually pertained to the case was her initial statement saying that she stepped on glass, and she explained that multiple times. That totally made sense to me. The reason why she originally lied, like I think somebody else was speaking on that. She wasn't.
But she even lied about the relationship she had with him. She lied about that.
To me, like her being like odd or the ooting, that didn't really pertain to that, like her personal relationship. I understand like she did lie about that, but literally all three of them basically lied about what was going on between them.
And then there was a gray area where she said that she was walking away. So at one point, it wasn't clear until they started pressing her a little bit more if she had even seen who shot her.
Well, she turned back because he shot her 5 times. Like at some point, you're not gonna keep not looking. Like I'm
Hmm.
pretty sure originally I mean, that's where most of the bullet fragments was at. It was in the heel of her feet, correct?
And
That was
so
in
a
the.
logical person, let's say me and you get in the car, all right? And one time is one thing. Me and you in the car, you in the car with your man or whatever, your friend, bestie, whatever. And I
Mhm.
commence to shoot at you 5 times, hit
Mhm.
you once. Are you going to get back in that car and lie for me?
My only thing to that, Armand, I know like us on the outside looking in, that makes perfect sense. Of course, I'm going to say absolutely not. I would not do that. But to keep it real, you don't know what you would do unless you were in that situation and
Uh-huh.
in the person. Like these are celebrities we're talking about. They're always trying to keep mess down. They're always trying to make sure that their name is not ending up in the blogs or on the news or anything. So I could totally see them lying about this. Other celebrities have done that before. I think who was that did? I think it was Lana Richie hurried up and bailed his ex-wife out, and she has straight up attacked his mistress, some white woman or whatever. I don't know if I can say that white tea woman that was in the bedroom, but he hurried up and bailed her out. Now, because he wanted her, he did that before they could get a statement or anything. The next morning, they had like nothing. They had nothing. So, like, even though the police officers, it really was just based on their testimony saying, hey, we picked them up. We know what she did. She attacked them, attacked us too, or whatever. But like this is common for celebrities to try to hurry up and smother any type of news like this. I could totally see her not wanting that to get out. Both of their stars were kind of rising at that time still. And if somebody is in shock, who can say what they would do in that situation? Like being shot 5 times by somebody like, oh, I'm sorry, I don't know if I was supposed to say that. Like being like having a ooting 5 times by somebody that you have been sleeping with, you considered a friend or whatever. Like I could imagine she would be in some state of shock, especially if they had been drinking or whatever else they have been doing. It just seems like none of that is being considered. That like make why
Mm,
would you make a decision like that? Like we're acting like she's a robot or something, has no feelings. Like shock is very common. It's very common. I could see her
okay.
making a decision. So look what Kelsey did. Her first thing, what happened? Did she hurry up and call the police? No. We're talking about people who are famous. She hurried up and called the security guard, like help, Tory, Aunt Meg, or whatever. So I just feel like the smoking gun is the victim is still living, and she
Okay.
testified.
Sarah,
She
what you
testified.
got? What you got, Sarah?
I
Okay,
just
thanks,
want to say I
Armand.
love you so much.
Thank you.
So I'm trying really hard not to be biased, but I just feel like there are so many obvious facts, like let alone the fact that she went to the ER and that ER doctor said that that wasn't a gunshot wound. And I feel like I don't know why that's not brought up very much
Hmm.
because when you see a gunshot wound, even
They did say that. They said it was not a gunshot wound.
yeah, and I feel like not only that, but when you see a gunshot wound, like even years later, it has like a certain look to it. And I feel like it's kind of an obvious, like you don't even have to do much explaining because this is a gunshot wound, this isn't. And there's no entry and exit point. Like I just feel like between that and the DNA, it's almost obvious what the answer is for
What is
me.
the answer?
I do not think Tory shot her. I don't.
Oh. Tiffany,
I gotta say it.
what do you think about that, Tiffany?
So I'm glad you are asking me because I wanted to speak, but I didn't want to speak over her or anything. So they did say that that wasn't a gunshot wound, but they also did say that these were definitely bullet fragments. Where do bullets come from? They come from a gun. So if she got bullet fragments pulled out of her feet. She was shot. Now, I will say this: I never thought that Tory did that on purpose. I never thought that he was trying to attack her. To be honest, I think it's like a short man syndrome or something like that. And he was just trying to play the big. tough guy, or maybe doing something that he saw off of a movie where they would shoot at people's feet as they dance or something. I don't know. And he was drunk. I think he was trying to do that like as a joke. I do not think he was intentionally trying to hurt her, but I don't care. If we have a car crash and you K-word my child in a car crash, I'm not trying to hear it was an accident. Like, you still have to pay. There's still consequences for that. And I feel like his consequences would have been less severe if he would have said that, hey, this was an accident. I didn't mean to do this. Even with Meg, I don't think she would have testified to the extent that she did. She was originally trying not to press charges on him until he did get online, basically insinuating that she was lying, even though she hadn't said anything, or that like something was going on between her and Kelsey and everything. She literally had no choice but to go ahead and get online and identify him. He did the same thing with August Alsina. August
And
Alsina was being quiet about the situation.
the fact
And when
that
Tory,
like they both were being intimate with him, I feel like that matters a lot as well, because
trying
there
to
was
run
so much hostility between them because of Tory.
Go ahead, Sarah.
You know what I mean? Kind of like, because this is how, trying to simplify it as much as I can, this is how I see how that night went. They were at Kylie's, right? Some sort of disagreement happened. They left. Megan left, came back, got Tory. And when they left, the three of them, or I guess the four of them, that was when a fight broke out. So I feel like there had to have been something going down between Megan and Harris. And I feel like maybe he tried to stop them from fighting. Maybe she found out that him and Megan were fucking. I don't know.
So
I
what
feel like
happened was Megan was already getting jealous because Tory was there. First of all, what happened was Megan went to Kylie's house. Kylie asked where Tory was, wanted Tory to come over. Megan called Tory. Tory had been sleeping with Kelsey, dating Kelsey first. During the quarantine radio 2020 pandemic, Kelsey had ended up getting COVID. Megan ended up going to Miami where Tory was living, ended up sleeping with Tory Lanez behind Kelsey's back. They ended up starting a relationship. That's how it started. They became cool. Kelsey, Megan all go to Kylie's house. Kylie says, "Where's Tory?" Megan invites Tory over. Tory and Meg are flirting in the pool. Kelsey is face drunk. She's upstairs. Kelsey has no idea that Tory and Meg are fucking each other, right? Megan gets jealous that Tory is over there finger popping Kylie in the pool. She leaves. They leave because Kelsey's drunk, and Tory says, "Okay, my Twan is gonna take you guys home," but he was gonna stay there with Kylie and do what he was gonna do. Megan says, can you believe, Kelsey, that he's there with that white bitch?" And boom, 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 as they're leaving. So Megan makes it seem like she left her Louis Vuitton slippers there. And so she tells Twan after they had left, "Hey, drive me back to Kylie's house. I forgot my stuff." It wasn't about that. She wanted to go get Tory out of that white woman's house. So she went and got him, cursed him out. There was a big scene there. That's when Kylie came out with her 6 big black security guards and told them, "All of you motherfuckers, get the fuck out of my house." So Tory got kicked out. Kylie got kicked out. Megan got kicked out. They get in the car. They're driving. They're arguing. And Tory says, "B, you want to do all this? Well, why don't you tell Kelsey the truth? Me and you been fucking."
Yeah.
And then all hell broke loose. Megan actually was in the front seat first. Kelsey was in the back seat sitting next to Tory. Okay. And he exposed it all. Then Kelsey was telling him, and Megan was telling him, "You ain't shit. You're just a feature on the White Boy record. That was the record. I forget what the white guy name is, but it was a rapper." And so they're going back and forth about music stuff. Megan says she wants to leave. She gets out the car, but then at some point, Kelsey and Megan start fighting, and then all of this starts to break loose. They get back in the car, then I guess she gets out the car again, and then the gunshots thing starts happening. So that's what happened. So they found out that Megan and Tory was sleeping together, and that blew everything up.
Oh yeah. Yeah.
So it's a mess. So where do we go from here? Do we think Jack Harlow, that's the guy.
Oh, yep.
So do we think that this appeal will be overturned? Do you think that he'll get out?
And in my opinion, I am 50-50, because I feel like at the end of the day, you know, I hate to say this, but Megan has one hell of a team. And there, even with the whole thing going on with that blogger, Milagro Grams,
Yes.
even everything going through with that, I'm like, I can't believe what they're putting this girl through. So, like, I just feel like maybe Megan is out to prove something, and she's not gonna give up easy. I feel like
Well,
even
in
if
the
he does
Milagro
win the
Grams
appeal,
case, no, Milagro Grams is no victim.
yeah.
She literally inserted herself and wanted to be a part of Tory Lanez's dream team. And so she didn't understand when to get off the gas and hit the
So
brake.
she wasn't just covering it.
No, she was
Oh,
in and out with the family. Allegedly, she was receiving payment. And she had became a mouthpiece
yeah.
for Tory Lanez. And, you know, I think that she was trying to build a platform. I think, you know, she was being promised a podcast deal. There was just things that she was trying to do because it was giving her notoriety, and she had gained an obsession for Megan Thee Stallion. So, you know, even years after the trial, she would not get up off the gas. So everything that Megan did, she would do it with an undertone of protecting Tory Lanez. And so at
Yeah.
this moment, Megan's team, going back to what you're saying, they're like, all right, Tory's got a blogger out here doing the work for him. So we thought we got rid of Kelsey because Kelsey's gone. We got rid of Tory, but then you got this blogger lady out here still pushing this, and is driving more hate because there is a big free Tory Lanez, you know, community out there that Megan deals with every day to this day. And then you have this woman with thousands of followers pushing their audience to troll and drag Megan at everything that she does. So you know what Rock Nation said? We're going to wrap her up and put a bow on her and get her out of here too.
Yeah. That's
being paid.
Okay, thanks guys for calling in. Love you.
Bye.
Bye. Yes. So this is where we are. And child, we'll see. Someone said, just because Megan is alive, so what? That's not a smoking gun. She's a liar. Some people are quick with lies. They said Milagro Grams was the person that was speaking truth about the case. We don't know, because the problem is, even if she was speaking truth about the case, she should have did it from a place where she was feeling non-personal. She got too personally invested. It's one thing to speak truth about the case, but once the case is over, move on to the next case. She would not move on. She took that case and put it on her back. That is what you guys are missing. You can have an opinion. You can report the case good or bad, whatever you feel. But you, after the case is done, you don't have to keep pushing and pushing and pushing. She kept going, and it became harassment. The deep fake videos had nothing to do with the case. There's a way to do it. So, all right, guys. Well, we got into some things. We'll be back with some more updates as they come in, more trials and more things to come. They said no one has moved on. Not even you. You a damn lie. You a damn lie. What are you talking about? Every case I cover, the devil is a lie, ho. Every case I've covered, I do the case and I move on. We're talking about it today because there was an update. You don't see me at the pillars in the post trying to go one way or another. I'm not on here every day saying that Tory Lanez shot Megan, and you know this is why, and pulling up evidence and going down Instagram pages and researching people's families and mothers. I'm not over here saying Tory Lanez is innocent, going through Megan's YouTube videos from early 2000 here and trying to put this together, and we're 2-3 years out. Hell, I'm not even doing that with Diddy. There's still people trying to add this and do this. It's like, and that's still more relevant. You did the case, you made your money, you got the news out, get on to the next case. Why are you dragging it out? You're taking it too personal. And it's hoes like you, it's bitches like you that got her in the situation that she's in now. And so instead of being here telling me what I'm doing, you need to advise that hoe, or better yet, send her $20. because she's going to need it. And I hope you'll be at the courtroom November 17th in Miami. She's going to need your prayers.
Shit gonna get ugly. Okay?
Okay? Now, with that being said, yes, so we're here. And so we got into some things. I love you all. And we're going to, somebody said, now, why would you have to call her names? Because it's fun. That's why. I'm not mad at her. If I didn't like her, I would have blocked her. I didn't block her. We just kiki in. A little entertainment. Untie your bra strap, babe. Pull your panties out your ass. You're feeling a little uptight. Maybe you need to fart. Let out some energy. You know what I'm saying? It's too early in the day for you to be feeling this uptight. It's the beginning of the week. Relax. You always be too uptight. Anyway. So yes. All right, guys. Love you all. And I'll see you guys in the next video. Subscribe to the channel, like the video, share with a friend, and I'll see you soon. Peace out.